Please, Your Lordship.
Yes.
I beg to mention item number 4, my lord.
Okay. On the prayer of Mr.
H.K. Sharma, respondent number 3.
Learned Counsel for respondent number 3.
Lord, in this case, we are appearing for the Numoligo refinery, my lord. It's
Hmm.
our petition.
Hmm.
My lord, there is some urgency in the matter.
A date maybe?
Next Thursday?
Next
A Thursday?
No.
Yeah.
January.
Huh?
I'm not having.
Could you?
And as it-
Taking time, my lord. Last time also they took time.
You use.
Let it be on, my lord, next week. Next week.
And as agreed to by learned senior counsel, Mr.
All right, let it come up on, my lord, 8th of January, my lord.
This matter on 8/12/2025. Yes. Yes, 8
8th of January, man.
January.
Yeah.
Okay, 8th of January.
Much obliged.
time
No, no.
8th of January. Okay.
Met please, Lordship. I'm praying for listing a motion matter tomorrow, Lordship permits, my lord. It is against the recovery proceeding initiated by Income Tax Department, my lord. All the bank accounts of the petitioners are freezed, my lord.
Hmm?
But during pendency of the appeal, my lord, bank account of the petitioners are freezed by the Income Tax Department, my lord. I'm praying for listing tomorrow, Lordship permits. Much obliged, Lordship.
May I please, my lord? My lord, this matter, my lord, motion matter, my lord, may it come on 28th, my lord.
After a week. Next week.
Obliged, my lord.
May I please, Your Lordship, I would like to mention the CR contempt case number 476/25.
After 2 weeks.
Madam, Lordship, matter may be withdrawn. For item, you know, my listing one, I mean,
Today. Withdrawal.
yes, or Lordship.
When do you want?
On tomorrow? Oblige, Your Lordship.
May I please, Your Lordship? Lordship, I'm praying for withdrawing one contempt case for tomorrow, Lordship.
Hmm.
Oblige, Lordship.
Yeah, please, Your Lordship, I beg to mention item number 16 and 17 of the supplementary list. We want to file a counter affidavit, so kindly 4 weeks' time may be given.
16 and 17.
4 weeks' time may be given, Lordship.
Lordship, a date may be fixed for this matter.
No objection.
Obliged.
On the prayer of MS.
Tin Lung,
For
the Dimahasa.
understanding of Dimashq. This and we are not being objected to by learned counsel MS so and so.
Yeah,
What of you?
Petition
Petition.
item 16.
petitioner
petition
item
item
17.
You just said MS so and so. Then counsel for petitioner in item 16, huh?
17.
17. Otherwise, your name please?
AI Kathar.
AI Kathar. List this matter after
4 weeks, Lordship.
4 weeks.
Lordship, a date may be given.
So as to as well have to qualify.
Obliged, Lordship.
Lordship, a date may be given.
Just choose the date. You choose the date.
Maybe January. January. তার মাঝে কাম নকৰিলে হ'ব।
Post Bihu, Lordship.
Hmm?
Calendar is not there, Lordship.
25th January.
Lordship.
2026.
Obliged.
May it please, Your Lordship, I beg to mention listing of 2 matter read petition, Lordship. And they listed after 2 weeks. Suspension matter, Lordship.
New matter.
Suspension matter.
New matter. Motion.
Oh, yes, Lordship.
Motion matter.
Yes, Lordship.
New matter.
Yes.
After 2 weeks.
Yes, Lordship. Mass oblige.
Unless I'm praying for an adjournment today, madam, on behalf of additional AG, madam. Any other day may be.
What is this?
Lordship, we have been allotted, my lord, the land, petitioner number 1244, my lord, already patta has been issued, my lord.
Hmm.
And petitioner number 45 to 59, my lord, patta has not been issued till date, but allotment was given, my lord. And their apprehension is that, my lord, in the last week of August, August, my lord, forest authority, my lord, visited our house
It
and
doesn't matter. They'll once, if they find that you have to be evicted, they'll follow the procedure. As last occasion, learned additional AG has said.
yes, my lord,
They're just apprehending.
apprehending, my lord, they visited our house and
Not how,
asked,
they have
asked to
visited.
submit, asked to submit the document, my lord.
You submit the documents, what's there?
Lordship, before that, my lord.
Where is that? Where is that?
One joint.
Where is that?
One joint verification was already conducted, my lord. and,
Where is that, that you have been asked to submit some documents?
Lordship, in paragraph, Lordship, paragraph 10, my lord, of the petition.
Have you submitted your application, the documents?
Lordship, they verbally asked, my lord, they.
No, there was an order that petitioner in the
Petitioner,
meantime be at liberty to submit their bona fide claims of right.
And my lord, earlier, my lord, one joint verification was already conducted and submit additional.
What's
district
the
commissioner
problem to submit your claim?
First, they have to issue the notice, my lord.
They have not decided as yet. They are just verifying verifying the area. Anyway, I heard Mr. So-and-so, counsel for the petitioners. Mr. I. Botakur, Learned Standing Counsel Forest Department. Press, about Learned Additional Advocate General. For 4 weeks to obtain instruction. Obtain instruction. Praise the Lord, this after 4 weeks.
Most of them.
So.
Here also, my lord, same favor.
Same order.
Lordship, we are not protected, my lord. No interim order is there, my lord.
Huh?
No interim order is there, my lord.
Earlier case also there is no interim order.
No, Lordship, in this case, my lord, already notice is served, my lord.
You submit the reply. You respond to the
I-
notice.
I submitted, my lord.
So. They'll decide. Then we will see.
Yes, my lord. They will decide.
Notice has been issued here.
Yes, my lord. I already submitted, my
Same
lord.
order.
I already submitted representation, my lord.
Yes, they'll consider it.
Yes, my lord.
Last occasion, no interim order was passed.
No, my lord. No interim. They assured the court, my lord, page 62, my lord. Kindly see page 62, my lord. This assurance
This one.
may be continued, my lord. Page 62 is the assurance, my lord. In affidavit in opposition, my lord.
You have not spread anything on the first day when the matter was moved.
Press, my lord, they,
File an appropriate application, will consider. If there's a imminent likelihood of evicting you.
Lordship, already they issued the,
Eviction notice.
yes, my lord.
Then why you have not spread on that day?
We challenge the eviction notice, my lord.
Huh?
We challenge this eviction notice, my lord,
No.
in this petition, my lord.
Did the reply,
Earlier we have submitted, my lord. Our representation was not considered, my lord.
a sport for agreed by Lance Court Party, this is the case on 17. it is learned constable has submitted, he will make endeavor to produce documentary evidence in support of the petitioner's claim in the form of chita, etc. on the next date of listing. Where it is?
We submitted, my lord, in
Where it
affidavit.
is? Have you brought on record?
Yes, my lord, in affidavit in reply, my lord. Page number 88, my lord, affidavit in reply. My lord.
Eighty?
Number 88, my lord. Our land is not, my lord, forest land, my lord. We also annex, my lord, Boonoksa, my lord. Page 96, my lord, and 97, my lord.
Yes, we'll see. Same order.
Till next date of listing, my lord, we may be protected, my lord. Already assurance was given to the court, my lord.
Perhaps you might have prayed that on the first day when the writ petition was moved.
Yes, my lord.
Then
This assurance may be continue, my lord, till
Huh?
next date of listing, my lord.
what assurance?
Oh, page 62 may be seen, my lord.
See? That first. Don't evict them.
Yes, my lord.
I'm not trusting any order, huh? I'm just verbally I'm suggesting.
Yes, my lord.
Yes.
Most of it.
Well, please, Your Lord.
Yes.
Your Lordship is aware, under section 32 of the POCSO Act, the state government is required to appoint a special PP. That provision has been interpreted by the Supreme Court also. I'll place the judgment at a later stage. The facts in this case are not otherwise in a very narrow compass. What had happened was, this particular proceeding was sought to be continued without, in absence of a special PP.
Matter maybe after time, there's passover timing, senior government advocate will appear in this matter, Lordship. Pray some time, Lordship, after some time.
Yes.
Lordship, the claim is admitted and undisputed. The respondent department is suggesting me to offer a equal portion of land instead of monetary compensation. But I have claimed more than that, and negotiation is going on that subject. Some positive outcome is coming. So it matter may be fixed in the mid of the December any date. In the meantime, something
If
will
that
come
is
out.
the case, we'll close it.
No, Lordship,
You
No.
settle it.
no. There is some negotiation.
Heard Mr. So-and-so, learned counsel for the, what is your name? FJ Majumdar.
FZ
Majumdar, learned counsel for the petitioner, who submits that efforts are being made to settle the matter outside the court. Therefore, prays for listing of the matter after 6 weeks.
Lordship, not 6 weeks. The outcome, the matter will be solved. Negotiation is going on. She is here in the mid of the December. Any date may be fixed, Lordship. Pendency of the matter may not serve any purpose. That is why I am praying, Lordship, to fix
You
a
just
date.
clear and come back. When is it settled? You make a mention. We'll allow it. We'll mention. We'll allow it.
Then 2 weeks or 3 weeks.
4 weeks. Make it 4 weeks. 4 weeks, huh? If it is settled in between, you make a mention. We'll list it.
Lordship.
In this case, KAC is supposed to file affidavit, Lordship.
Why? Mr. Sujaya,
My lord, I have received the instruction, my lord,
And Mr. So-and-so, learned counsel
It
for-
can be disposed of if the petitioner agrees, my lord. The appeal is required to be filed before the appropriate authority. Petitioner has not filed the appeal.
Lordship,
If-
I have filed the appeal, Lordship, which I have already left an
My lord, as per the Karbi Anglong Land Revenue Act, my lord, appeal is required to be filed before the executive member in charge, my lord, Revenue Department. He has not filed the affidavit along with the fees required to be paid, my lord. So if he files the appeal, we will dispose of the appeal, my lord. And then if he is agreed with the decision of the appellate authority, then he can approach the court, my lord. It can be disposed of like that way also.
Lordship,
If he
in
agrees.
this- Lordship, in this case, I have to take instruction, Lordship.
Then, my lord, we'll file the affidavit to that extent after 4 weeks.
Mr. J. Learned Student Council, KAC, submits that. As per the, what is that?
Karbi Anglong Land Revenue Act 1953.
As per the Karbi Anglong Land Revenue
Act
Act
1953,
1953.
the appeal is required to be filed before the
An appeal lies before the
executive member in charge Revenue
executive
Department.
member in charge
Revenue Department,
Revenue Department.
KAC.
Please, however, the petitioner has not filed any appeal. Therefore, the petitioner may avail the remedy under the law. Mr. So-and-so, Land Council, Bordoloi,
Lordship,
the petitioner submits that he may be granted some time to obtain instruction.
Lordship,
Praise the Lord, this matter after 3 weeks.
Lordship. Oblige, your Lordship.
Prayer is allowed, huh? Prayer for the land council petition is allowed. Only just after 4 weeks.
So this matter, madam, with the consent of the second, can be taken up on Thursday, madam. AG, additional AG will appear.
Next, although the division bench has requested that the present rate petition be disposed of within a period of 4 weeks. The parties have prayed for another date for hearing of the matter, for consideration of the matter. Just considered about, let this matter be listed after a week.
Big state, madam.
27th, day after tomorrow, Lordship, they are praying for.
Thereafter, next week, when it is cannot be already decided within 4 weeks. We have taken a time last time also.
In that case, Lordship, we have urgency, that's why we are praying for day after
Therefore,
tomorrow.
next week.
They are praying for day after tomorrow, Lordship.
Next week, any date.
Next week, board date, sir. Hearing date.
10th period. Next week, 10th.
10th. Public. 9th.
9th, we might,
Hearing.
they will out of space, 10th or 11th.
11. 11.
But I appear in item number 7. Your lordship will kindly peruse the last order. There is a requirement under section 48 of the act for carrying out a delimitation exercise. There is a judgment of a division bench long back. Several years have passed. That exercise is yet to be undertaken. On the last occasion, an assurance was given that within two months it will be done. Our instruction is even now it has not been done. There is an order passed on 8th of September.
My lord,
September.
my lord,
I have an instruction, my lord, that government is deliberating on the thing. We have, my lord, amended the act even for that. My lord, it takes some time, because public,
You have last, okay, you said 2 months.
my lord, my prayer was to leave the matter after 2 months, my lord. In the meantime, we are doing it, my lord. My lord, our
Initiating the
delimitation,
limitation process pursuant to increase of number of constituencies and the entire process may require at least 2 months for that time.
my lord, my instruction, my lord.
This has been going.
It's still process.
It's a process, my lord. It's a process, it's in process. Because, my lord,
Now finally, how long you will take?
my lord,
Process may take time, but initiate it.
But the division bench judgment is of 2016
Hmm.
and we are in 2025, end of 2020.
my lord, in division bench judgment, there was a specific direction that you have to go for delimitation, my lord.
But it's
Division
the
bench-
mandate of the statute.
My lord, division bench only observed that, my lord, to look into the matter. My lord, we have gone into it. For that, then first, what we found, my lord, that we need to
Have you
amend
filed the affidavit?
This affidavit.
we filed, my lord.
You have filed.
We have filed, then, my lord, then the courts came in that we will go for delimitation.
Hmm.
Then a hurdle came that the act has to be amended. We again, it took some time for amending the act.
Hmm.
Some constituencies were increased in the area, my lord. So, my lord, these are the, my lord, the thing is that government is not sleeping, my lord. But, and very sensitive, my lord, because that.
What is the rationale or reason behind the curtain?
No, not cartel.
Amendment
No,
and then saying that we will initiate,
no,
still deliberating.
my lord.
Is there anything
My lord,
rationale behind,
there is, my lord. The thing is that
behind the curtain?
there is, the demography of the area is very sensitive, my lord. Tribal, non-tribal. So we have to, my lord.
Anyway, so you are saying that you are going to do it.
My lord, yes, we always said that, my lord, we are doing it. we are deliberating.
Another month.
My lord, let this come in the month of-
Completion, we don't know, but then at least you initiate if you want to do it. And if you say that you cannot do it or you are not going to do it,
No, my lord, we never.
then in that case, we'll hear you. But if you are going to do it,
No, my
we
lord,
understand it may take time.
We never said that we will not do it.
Huh.
Our stand is, my lord. Only for this doing only, my lord. And behind the back, my lord, we are trying to give them so many things. Trying to carve out a, my lord, a council there.
Anyway, so
Lot of things are happening.
another 2 months.
Another 2 months, my lord.
And your lordship will make it clear that this, because this writ petition has been pending just on this ground, it has been pending since 2021 and every time the matter comes up, same prayer is made. Your lordship will have a look at the orders, man.
With an understanding that they will complete within 2 months.
Yes.
We'll grant them.
I have 6, my lord. My
Huh. Or Mr.
is fine.
Huh?
2014 matter. My matter is 2014.
Okay. See, it takes time. The process takes time. That's why I've asked him, is there anything behind the curtain?
My lord, delimitation, we have to, my lord, very sensitive issue, these are, my lord. We
But
have to
it
carve
is a
out-
mandate of the act. We are simply asking for implementation of their own act.
What is the amendment? Is there any change in the?
No.
We have increased, my lord, the number of constituencies in that area.
Yes. Then what is the difficulty now? What is the difficulty now?
My lord, once we have, my lord, increased it, my lord, now, my lord, we have to go into the population pattern, how to do it. There are, my lord, this is an area, my lord. My senior friend.
That's
also-
why I'm asking.
My lord, whenever we have tried to go there, my lord, delimitation, my lord. My lord.
We'll lift the veil. If
Well-
there's something behind.
No, but there is nothing as such, my lord.
Extraneous consideration.
No, nothing as such. From our side, my lord, we are just trying to be, my lord, be with the people, my lord. That's it, my lord. So, my lord,
Obviously, you have to be.
very, my lord, we are taking a holistic view in this matter, and we are going, my lord, we are approaching everybody. Public meetings are being held, my lord. We have 2-3 rounds of meeting also, my lord. Means we are trying to accommodate everybody. It is not that easy, my lord.
Okay.
That's a tribal area, non-tribal,
Okay.
population is very high.
Mr. I. Chaudhary, Learned Senior Counsel, assisted by so and so in writ petition 6657 of 2021, and Mr.
Yes, yeah, my lord.
Learned Counsel in writ petition
I require 7 of 2000.
517 of 2014. Next paragraph. Considering, having considered the submissions of Mr. Ardhar, Learned Standing Council, Tiwa Autonomous Council,
No, my lord, I am for Tribal Affairs Department.
Tribal Affairs Department, comma. This court to the effect that the government is in serious contemplation to initiate the limitation process pursuant to the increase of number of constituencies, and the entire process may require at least 2 months further time, comma. Granted, has granted has allowed the prayer for adjournment to 2 months. However, today, Mr. Arthur, the Standing Council, has reiterated that the government is the process, the government is under process to initiate the said delimitation process, which would take some more time and press for further 2 months time.
My lord.
2 months time. Considering that the government appears to be initiating the delimitation process, comma. The prayer for adjournment is granted. Another 2 months, another 2 months time is granted as prayed for by the Learned Standing Council. List matter after two months, we'll say 2 months.
Your lordship will make some kind of an observation, but otherwise this has been going on for 4 or 5 years now.
We'll
Same
see.
prayer every time.
On next date, we'll see. Can we see?
My lord,
Other writ petition is since 2014.
Your lordship may fix a date in January.
Ultimately, we'll have to direct them again and do it again. They will say all these things. So it's better not to make
None.
any further.
In that case, my lord, the date may be fixed in January.
Last part of January, after 2 months.
28th of January.
Met please, Lordship. Lordship, order dated 10/11 may kindly be perused, Lordship. My learned friend was directed to take instruction on the financial approval, Lordship.
Yes, Lordship, here I have inquired about the proposal, Lordship. There is some confusion, Lordship, because they have said that the proposal has been sent back raising certain queries to the transport corporation, corporation department, sorry. Lordship, if I, Lordship,
What is the order?
Lordship, order, Lordship, will get page 25, Lordship, relevant. Lordship, order was that the respondent number 2 sealed the house of the petitioner illegally. So this one, there are 13 may kindly be perused, Lordship. Page 25.
A cost of rupees 1 lakh was imposed upon the respondent number 2, Lordship.
Yes, who is for the cooperative,
Hello.
registered cooperative?
I'm appealing for. My lord, we have forwarded the, we have,
We are not concerned. Direction is to, this is a cost only.
my lord, my lord. My lord, we have a
The
proposal. has
cost
been-
from where you get the money is nobody's.
I understand, my lord, but there's a process, my lord, we have
No,
initiated.
Lordship, if I may, Lordship, on the last day, they had submitted
Yes,
that a
submitted.
proposal was sent to the finance
Finance
department. We were not made a party. I'm only assisting the court, Lordship. So, Lordship, I've inquired from the department. Lordship, they are just, Lordship may just pass over the matter for the timing. They will give me an exact instruction as to whether the proposal was received, where it is at this.
Okay, we'll take,
Yes.
we'll list after some time, but
Yes,
then
Lordship.
My lord, we have,
it's you.
my lord,
We are
have-
not concerned with the finance.
Yes,
Finance
sir.
is also
There's-
not party.
we can
Lordship.
only send it.
From where do you get, we are not
No,
concerned.
Lordship, I want to find out
We
whether.
just want that, you'll have to comply.
Lordship.
That's all,
Blessed.
after some time.
My lord,
Worship.
in the writ petition on the last, I'm just. On the
Contact.
last occasion, order was passed that the matter will be heard at this admission stage, my lord. But there was also contempt application, my lord. In the contempt matter, my lord, I have received the notice only on 21/11, my lord. If my learned friend wishes to press the contempt, then my lord, I'll have to file an objection here. And if it is otherwise, if the writ petition is heard, my lord, I am ready.
I want to praise.
I'll have to file my objections because it is a civil matter, civil dispute, my lord. And the private respondents have been made contemners, so everybody will have to file.
It
the
is not a
individual
civil matter,
affidavit.
it is a writ petition, it is different from civil
My
matter.
lord, I
Civil
will
case,
establish
lordship.
before your lordship that it's a pure, simple civil case. Where this,
Then
and
also
later
there
part-
is a breach of the
later part,
order.
my lord, whether it is a civil
See,
case.
we're not hearing it now.
Yes,
If you want to file
Yes, my lord.
affidavit,
Okay.
and if if she's pressing, we'll grant you a time.
Lordship.
Are you pressing the contempt?
lordship, contempt, because my learned friend is asking for some time.
Ah,
1 week time may be given for filing of the,
10 days time, my
Hmm?
lord. 10 days time, my lord, because
Ah.
private contemners are there and they are.
on MSM, they learned counsel for the petitioner. Next para, Mr. G. Rahul,
See, Rahul, my lord.
learned counsel. Enters appearance on behalf of. You have already appeared.
I have already appeared, my lord. We have
Uh,
filed a
who-
affidavit and everything.
and learned counsel for the Alice contemner
Let's go.
submits that he may be granted 10 days time to file an affidavit in opposition. File a response to the contempt petition. List of praise the Lord. 10 days time is granted to file a response to the contempt petition.
no date may be fixed, lordship.
List after 10 days. After 10 days, you list.
8 I will be out of it, 8, 9 or 10. 10,
10 o'clock, 15 o'clock,
So the writ petition will come up.
along with that.
Can it be after 15, my lord? Some
No,
from 10 to 15, actually, otherwise, before 10, if it is listed, I don't have any problem.
Before,
Before 10,
okay, before 10.
kindly see it, before 10.
Yeah, it was before 10.
Offense assistant said that it will be at 8.
8 I will be out of, I have some other problem with my lordship.
9,
Only 8. 9 I can.
9, 9. Obligement.
And being ascending, when we ascending.
9 your lordship. Obliged.
May I please your lordship?
Lordship, my senior is legging on court number 9. Can you pass over this matter for time being?
Time being.
It is the Lordship. Lordship, here the petitioners are aggrieved by the dissolution of the petitioner committee and constitution of ad hoc committee by the circle organizer. That is respondent number 8, Lordship, which has been later on updated. As per the rule, Lordship, the respondent number 8 does not have the power and jurisdiction to dissolve the earlier committee and constitute a new ad hoc committee. That is the the petitioner, Lordship. In the affidavit also, it has been admitted by the respondent that he has constituted a new ad hoc committee and by dissolving the earlier committee, Lordship. And that is without power and jurisdiction, Lordship.
Admitted.
That is admitted in the affidavit, Lordship.
No, Lordship. The earlier committee failed to execute their Lordship duty properly. The earlier
But
committee.
who has the authority to dissolve and constitute a new committee?
Yes,
State
Lordship.
government Lordship.
Ah,
State government Lordship.
so who has done it?
That is, the circle organizer has done that, but
Who is the circle organizer?
Lordship, respond number 8, Lordship.
Hmm.
And as per the rule, Lordship, kindly come to page.
Is no government, is not government,
He is,
is not a government of servant.
That's number 8.
Lordship, kindly come to page number 18, Lordship. 1-8, that is the rule that has been provided the.
18.
Yes, Lordship, 1-8. Chapter 3, Lordship.
Hmm.
Rule 11, appointment of the cycle organizer, village defense organization, Lordship. Appointment, may I read, Lordship? The appointment of the cycle organizer shall be made by the district village defense officer, who shall be the appointing and controlling authority. The education qualification of the cycle organizer, village defense organization shall be matriculate. This may, however, be relaxed in the case of candidate having special qualification in the special work who has distinguished himself by sincere and devoted service to the village defense organization, for who, by his position and status, inspires confidence in the mind of the public. Prior approval shall be obtained from the chief controller, village defense organization for appointment of such education qualified persons. The candidate must be citizen of India, native of the district. The age limit shall not be less than 18 years and more than 30 years. In case of scheduled ST and ex-servicemen, the selected candidates must be fit on medical examination and the police verification. And here is duties and responsibilities are also there, Lordship. He shall be responsible for frequent supervision and guidance in regard to the duties, responsibilities, and activities, and keep close touch with the Thana village defense officers. He shall submit progress report to the district village defense officer through the.
So what is the power, what is the provision for dissolution?
That is, Lordship, it is not here. He doesn't have the power, Lordship.
Hmm?
He doesn't have his duties and.
No, he may not have, but event it has to be dissolved.
It was constituted in 2019, Lordship. I have to take the present status, Lordship, what is going on, because it was constituted in 2019, Lordship, 2025.
But are you admitting that the circle organizer has has no power to dissolve? Where is this order? Dissolving and appointing?
Dissolving, Lordship, allegedly, we are the committee, Lordship, and there's some notice that has been that is issued by the circle organizer, asking us to submit all the because, Lordship, as a Thana committee, we are maintaining the passbook, because as a honorary, the petitioner were getting something 2,500 rupees, Lordship. He was asked us to submit all this thing, and allegedly he has dissolved our committee and constitute his ad hoc committee, Lordship. That is in 2019, because we do not have this Lordship notice also.
There's no power to that's why I'm asking, who has the power to dissolve?
This is a tenure of 5 years, Lordship.
That's what I'm saying.
And after 5 years, it will reconstitute again, Lordship.
There's no power of dissolution.
Lordship, dissolution so far. Page number 21, tenure of the all committee, Lordship. Rule 19.
Hmm?
Rule 19, page number 21, Lordship. Tenure of all committee.
It's okay. Foreign function district village defense officer. Where is the order or any which reflects that it has been dissolved? Huh?
There's a note, there is some notice, Lordship, page number 38, Lordship.
Otherwise, how do we know that this village defense has been dissolved? Barun Ma, President.
In the affidavit, they have also admitted it.
You are hereby requested to submit all the documents mentioned below in police station.
In this regard, Lordship, we have also submitted representation, that is page number 42 to the Superintendent of Police.
Hmm?
In this regard, the petitioners have also submitted, that is page number 42, representation before the Superintendent of Police, Lordship.
This is by whom?
On behalf of the Village Defense Party under Mathurapur Police Station, Lordship, these are the
Who are the petitioners here?
members. I don't to pronounce it.
What is the power of this respond number 7? Oh, sorry, 8.
Yes, Lordship. Is number
District Village Defense Officer, not of.
Lordship, page number 18, Lordship, chapter 3. Rule 11.
Appointment of circle organizer. He is the all village defense parties in the circle are subject to his supervision and control. He shall be responsible for making systematic arrangement for watch and ward. You are under him only. where is the documents to show that the village defense parties has been dissolved? There's nothing.
No, we have made a statement, Lordship, without issuing any notice to us. He has dissolved a committee and he has constituted an ad hoc committee, Lordship.
Who is the authority to appoint village the defense party?
Paragraph 6, we have given the statement, Lordship.
Village Defense Primary Committee. What is the appointment?
Village Defense Primary Committee is formed by the District Village Defense Officer, Lordship. And he is Superintendent of Police, Lordship.
No, you saw the documents where the organizer has responded and dissolved and appointed a new committee.
Otherwise, tenure of the committee is 5 years, Lordship.
Where it is?
Page 21, Rule 19, Lordship, page 21. Tenure of all committee. ठीक है ना?
19.
Lordship.
Rule number 19, Lordship.
The tenure of all committees formed under these rules shall be for a period of 5 years from the date of formation of each committee, and on expiry of the terms, each committee shall be
All committee.
reconstituted as well as provided herein.
Hold it, है ना? I have to take instructions, the status of the present, what is where is the other committee working, or they have been maybe removed in the meantime, Lordship, because their tenure is completed. Because it is constituted in 2019. If it is 5 years, it is 24, it will over, Lordship.
Oh, Lordship, but the dissolution, I have to take instruction also. The dissolution notice by is anything, because the dissolution was without power and dissolution. And the petitioner was getting the honorarium, Lordship. They have been deprived from that, Lordship.
And MS then counsel for the petitioners and Mr.
And Goswami.
and Goswami, London State Council for the respondents. After hearing the London Council for what is what it is, after hearing the London Council, after hearing the matter at some length, it is seen that the tenure of all the committees, including the village defense parties constituted under the Assam Village Defense Organization Act 1966 is for a period of 5 years. And the present defense organization oblique committee appears to have been constituted in the year 2019. Stuff. Considering above, the tenure might have completed. Not prime minister. Consider above the view that since the tenure has already been completed, for the purpose of adjudication of there may not be any there may not be any surviving cause for adjudication in this proceedings. Accordingly, then counsel to the parties are granted a week's time to obtain instruction. Both of you obtain instruction.
Yes, Lord.
Otherwise unnecessary.
On 12th.
Obliged.
Lordship, I have received the instruction, Lordship. There was a statement made by my learned friend by the authorities in the cooperative union that the proposal was pending in front of final. Lordship, we had endorsed the file back on 28th of October. And now I have informed my learned friend to the officer with whom that file has been endorsed back on 28th of October. So Lordship,
My lord, may fix a short date, my lord. Miss MD Bora, she is a standing counsel. She is unwell today, my lord. She is in the hospital. She has not been able to appear.
Not a standing counsel, he is who is the registrar?
Yes, my lord.
Cooperative society.
Cooperative society, my lord.
He has to pay.
No, my lord. I understand, my lord.
It's a cost.
My lord, I'm stating that, my lord, my senior, MD Bora, she has not been able to appear in court today. So, my lord, may give a short date, my lord. We'll take the.
Lordship, I fix it on Monday.
On Monday, my lord. Coming Monday.
Mr. Swenson, learned counsel for the petition. On the prayer of it. Whatever is there, we'll take it up on Monday.
Monday.
On the prayer of Mr.
RB Goswami.
Learned counsel, appearing on behalf of
Miss MD Bora.
Mr. MD Bora.
Miss MD Bora.
Miss MS MD Bora. For the alleged contempt. Who reported in this post. Let this matter be listed on Monday, 01/12/2025.
Deeply obliged.
May I please your lordship? Lordship, in this case, lordship, we are challenging the order in original passed by the lordship adjudicating authority. Lordship, our main contention,
Yes.
lordship, we are challenging the order in original passed by the adjudicating authority. Lordship, the order which I am challenging is at page 145, annexure 6.
145.
Annexure 6. This has been passed by the additional commissioner CGST.
May I please your lordship? Kindly pass over the matter, lordship.
Small matter, lordship. It's a small matter.
He's on legs, Mr. KR, he will come, lordship.
Hmm?
He's on legs in court number 2, he will come, lordship.
Let her make her submission.
Lordship.
Lordship, in this case.
Hmm.
In this case, lordship, the order which has been passed, lordship, by the adjudicating authority, lordship. The service tax has been levied by this state order. Lordship, may kindly see page 160 of the order. Lordship, earlier the authority thought that my liability is 1,40 lakhs, but after hearing me, the adjudicating authority, lordship, at page 160, lordship will see what is the lordship service tax which he thought that
160, Lordship, 160. So this is for the assessment year 16-17, 2016-17, service tax, Lordship. Lordship would kindly see point number 10 in this case, Lordship.
The service tax liability of.
Of the petitioner of the said notice during the financial year 2016-17 against the various services rendered is summarized as under. So Lordship, they had said that this is the services I have provided. The gross receipt is so much and my service tax liability would be 72,33,010. This is my liability, Lordship, for service tax. Now, Lordship, this Lordship may kindly see page 161.
Notice he has deposited. Yes.
The notice he has deposited service tax amounting to 73,20,352. Lordship, more than the determination made already for this year. And interest amounting to rupees so and so into the government exchequer under the following challans during the financial year 16-17, but did not file their periodic ST3 returns. So my only wrong thing which I have done is that I did not find my periodic ST3 returns, but I have paid my entire taxes, whatever is due, more than what they have determined already. Lordship, when did I pay this amount? This amount is liable to be appropriated in the government exchequer. Lordship will kindly see the challan date is SBI challan number. Lordship, in the chart it is given the challan details. SBI challan number so and so dated 7/6/2017. All are 17, Lordship. May kindly see that I have paid the entire amount of money. Thereafter, Lordship, it is written that service tax which is paid and interest which I have paid. So I have paid all the amount in the year 2017 itself. It is not that after receipt of the SOCOS notice or after receipt of the order I have paid. I have paid before 2017 itself. I had paid, but they are saying that they are not able to trace my returns. So, Lordship, then what is the reason for passing the assessment order? Because I had already paid the entire tax. So, what was the reason? Lordship will kindly see from paragraph 11. Paragraph 11.1. This is their contention.
10.3 also you.
Yes, Lordship, I'll read 10.3. That is relating to director. I find that the said notice has charged service tax amounting to 99,000 on an amount of rupees 6,66,000, which is a remuneration paid to the director. Now this amount is beyond the scope of SOCOS notice. He knows that this is beyond the scope of SOCOS notice. The said notice should ensure that they discharge this liability also along with amount reflected at paragraph 10. So it is not that this is beyond their SOCOS notice. So Lordship, that is not the scope of this SOCOS notice at all. Lordship, thereafter the reason for levying tax on me, if I have already paid 11.1, Lordship, they have given a reason. Regarding the invocation of extended period of limitation, I find that the SSC suppressed the taxable value in ST3 returns. In the regime of self-assessment, the onus lies on the party to declare the taxable value applicable service tax on periodic ST3 returns. The misdeclaration of taxable value of the said notice came to the knowledge of the department only after receipt of information from other sources. Had it not been from the data received from the income tax department, suppression of taxable value by the said notice would not have been detected. The said notice willfully suppressed the taxable value with an intent to evade payment of service tax. So this is a standard paragraph which they put in each and every cases whenever they want to invoke extended period of limitation. Now this is not invocable in this case, Lordship. I have already paid amount long back, even before the issuance of SOCOS notice. Further, I find that it is a settled law that where demand of service tax has been held to be sustainable, tax defaulter is liable to pay interest at the applicable rate. Further, Lordship, 11.3 it is written, I am of the view that the legal requirements for invoking the provisions of section 73(1) EBIT for recovery of service tax beyond the normal period of limitation and the legal requirements of invoking 78 for imposition of penalty of the tax defaulter are identical. Therefore, I am of the considered view that once the provision of section 73 has been held to be sustainable in the facts and circumstances of the present case, penalty also is impossible in the instant case, and I hold accordingly. This is, Lordship, the entire Lordship, whatever they have found out. Finally, Lordship, the order which has been passed in the next page. Lordship, 12.1.
Appropriation of service tax.
72, I partially conferred demand of service tax including cesses amounting to 72,33,000. for the financial year 16-17 in terms of 73(2) for the reason discussed. I order interest on the above amount to be paid. I impose a penalty of 10,000. Till then it is okay, Lordship. I impose a penalty of 72,33,010. So Lordship, the entire exercise has been taken only to impose penalty on me. Even though I have paid the entire service tax and interest, I order appropriation of the service tax amounting to 73,20,000 and interest amounting to 6 so and so already paid by the said notice towards their liability. So this is the Lordship, the order which has been passed. Lordship, after we file this petition, Lordship, the respondents have filed their affidavit, making their
However, the
stand clear.
notice is given an option to pay reduced penalty equivalent to 24% amount of penalty imposed under section 15 subject to the person notice and improvement. Let's confirm under section 790 along with interest and taxes. Yes. It's just a penalty only.
This is only to levy penalty because at service tax I have already paid, interest I have already paid,
But
even
then-
before issuance of the SOCOS notice in the year 16-17 itself.
You have not filed that required ST.
That is the only allegation on me.
It's a suppression, therefore penalty can be imposed. What's
Lordship,
wrong? What's
10,000
wrong?
penalty can be imposed. I can say because Lordship,
How you are aggrieved?
Lordship, I am aggrieved with the imposition of penalty of 72,33,000 because Lordship, I will show from the section that it is very clear that if I have already paid this entire amount of tax and penalty even before the issuance of SOCOS notice, no penalty can be levied on me. That is the express provision of the Act, Lordship. I will show the
The penalty 72 lakhs is in addition to your service tax already deposited
Yes, Your Lordship.
under
That-
section 71A.
Yes, Your Lordship. Lordship, this I will, Lordship, show you, Lordship.
Then next, what you are saying, trying to say?
Lordship, their
Ah,
affidavit where they have
what they are
accepted.
saying. Hmm.
In the affidavit, they have accepted that I have paid the entire tax and interest. For that only, Lordship, I am relying on the affidavit filed by the
Enter service tax.
entire service tax has already been paid.
That is
even
not
before-
that is not dispute.
Not
The
disputed.
dispute is only the penalty, whether the penalty can be imposed or not.
Yes, Your Lordship. Lordship, in this regard, Lordship, let me
Said
play.
order
Your
was
Lordship.
passed on the basis of the representative did not dispute the service tax liability of stranger, which was confirmed.
Lordship, I
Yes.
place the Lordship one paper book where I have prepared the
Not where it is,
Lordship, the paper book I have placed.
where they have admitted, what you are saying.
Lordship, in the service, in their affidavit, Lordship, they have admitted, affidavit in opposition which they have filed. Paragraph 11.
Hmm.
Paragraph 11, Lordship, of their affidavit.
In order, original interest was confirmed, but it was already paid by the petition and so the amount of interest was appropriated. The petition did not require paying any more amount as interest. The issue of levy of interest has been settled. Yes, there is no dispute.
No dispute, Lordship, that I have
Dispute
already
is, the problem is the imposition of penalty
penalty, Lordship.
under section 78.
Lordship, why will somebody impose penalty on me if I have
Considering
paid?
this was stated, the personnel behind the imposition penalty under 7 Finance Act was discussed in 3.7 of order in original native so and so. So according to you, no penalty could be imposed
Lordship,
under section 78.
because I have paid.
Let us see the section 78.
Lordship, may kindly see section 73, Lordship, under which there is a bar, Lordship.
70?
3, Lordship, Lordship, may kindly see the paper book, page 110,
Finance
which
Act.
I have annexed the Finance Act, Lordship, in the paper book.
Bring it, please.
Yes.
The written submissions, Lordship, the written submission, page 95. Page 95, it starts, Lordship. 95. Index. Lordship, this is the service tax, Lordship, Finance Act 1994. Lordship will kindly see section 73 of that, which is at page 110. Pagination, internal page 16.
Hundred and ten.
Yes, Your Lordship. Lordship, section 73. Lordship, recovery of service tax not levied or paid or short levied or short paid or erroneously refunded.
Recovery of service tax not levied or paid or short levied, short paid or erroneously refunded.
So, Lordship, the provision of law, what he says, the section 73(1) says, where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded, Central Excise Officer may within 13 months from the relevant date serve a notice on the person chargeable with service tax which has not been levied or paid or which has been short levied or short paid on the person to whom such refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice. So Lordship, first he will issue me a show cause notice in case I have not paid the amount. In this case, Lordship, I had already paid the amount, so the show cause notice should not have been issued. Thereafter, Lordship will kindly see point number 3, subclause 3, which is at page 111 of section 73. Subclause 3, Lordship. Where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded, person chargeable with service tax or the person to whom such tax refund has erroneously been made may pay the amount of service tax chargeable or erroneously refunded on the basis of his own ascertainment thereof, or on the basis of tax ascertained by a central excise officer before service of notice on him under subsection 1 in respect of such service tax, and inform the officer of such payment in writing, who on receipt of such information shall not serve any notice in respect of the amount so paid. Lordship, the first proviso is not important. Lordship may kindly see, provided the central excise officer. Explanation, Lordship 2 is important, Lordship, here. This is in relation to when I have self-paid. In this case, I have already self-paid. For the removal of doubts, it is hereby declared that no penalty under any of the provision of this act, any of the provision, Lordship, 78, or rules made thereunder shall be imposed in respect of payment of service tax under this subsection and interest thereon. So in this subsection, if I have already paid the entire tax.
Respect of payment of service tax under this subsection and interest there, huh?
Yes, Your Lordship. So under this subsection, I fall under this subsection because I have already paid self-assessment tax 73 lakhs even before the issuance of notice.
So this 70, will it not apply only for service not levied or paid?
Lordship,
Or short levied or short paid? Yours is the case which has already been paid.
already been paid. Lordship,
You have suppressed according to them.
according to them, I have
Therefore,
not
therefore
filed
your
return.
penalty is imposed.
Yes, Your
That
Lordship.
is section 78.
Yes, Your.
May not be applicable.
That is also not
73
applicable.
may not
Section
applicable.
78, Lordship.
Section 73 may not applicable.
Lordship, 73 2, but it says that. Lordship-
Penalty for failure to pay service tax for reasons of fraud.
Yes, Your
Okay,
Lordship.
let us read this.
Where any service tax has not been levied or paid or has not been short levied or short paid or erroneously refunded by reason of fraud,
Is
fraud.
it, fraud or collusion
Or
or
willful
willful
misstatement
misstatement
or
or
suppression of facts
or
or contravention of any of the provisions of chapter, the rules made thereunder with the intent to evade payment of services. Intention has to be there to evade service tax. When I have paid, where is the intention?
Why you have not submitted that?
Lordship, the
record?
return I have submitted, they were not able to trace. That is the Lordship statement I have made. But still, even if
Oh.
I have not submitted, we accept the whatever they say. Even if I have not submitted,
Person who has been served notice under.
We paid the entire tax.
Cell, in addition to the service tax,
in interest.
interest, passive and license be also liable to penalty which shall be equal to
100% of the amount of such service tax
So according to it, neither the 73 nor 78 will be
will be
applied.
applicable. So Lordship, this the demand has to go, Lordship. Once
Ah.
we have accepted that tax and interest has been paid, penalty cannot be levied,
That's
Lordship.
all.
That is the short case, Lordship. Lordship,
Why it is preliminary as a written argument?
Lordship, because Lordship, time bar was also there, so I have made the entire submission relating to time bar.
What is the case laws you are relying? On which
Lordship,
point?
Lordship, the case laws which I have given is Lordship, if an Lordship,
Is it on section 73 or 78?
Lordship, neither 73, Lordship, I have in the written submission, I have given that I have quoted both 73 as well as section 78. I am given that under section 73(3), if we read, that bars them to impose a penalty under any of the sections under the act. Even if that is not read, 78 also bars them to impose any penalty. So in this case, penalty could not have been levied on me. So that is my case, Lordship, and Lordship, the judgments which I have relied on is only relating to the Lordship barred by limitation point. Lordship, that Lordship will kindly see Lordship, may I place the master circular, Lordship, which has been issued by them?
Only
Only-
one, not many.
No, Lordship.
How many judgment?
Lordship, the
Judgment.
judgments I have annexed in the order, Lordship, that regarding time bar, I am only showing the circular, Lordship, master circular. Lordship knows about the time barring. If anything is time barred, that it has to go. Lordship, I'm only relying on the master circular. This is issued by them. This is their master circular.
Hmm.
Wherein they say, Lordship, there are provision in the this ki what, because they have invoked the extended
Is
period.
a part of the record.
Lordship,
Is
this-
it part of the record?
Lordship, this is a official, because like an act, it is a circular which has been issued by them. It is not a part of the record, Lordship. Not a
How
part,
do you know?
Lordship, but that is a circular.
At least the council may not know. When it is not not brought on record.
Lordship, this is a, Lordship, I was just placing because it's a circular, Lordship, by them only,
Hmm. So,
issued by them. In which the extended period of limitation, when can it be invoked? Only for the limited purpose. Lordship will kindly see page
So,
6.
you want to try the, we want to remove the foundation.
Foundation, Lordship. Because Lordship, 16, 17, Lordship, at best they could have sent me a surplus notice within 30 months. But they have invoked the extended period of limitation and they have issued to me in 5 years. So when can they, in their own circular, they have said, when can they invoke
3.2,
Lordship? 3.2.
ingredients for extended period.
3.2 and 3.3, Lordship, they themselves have said, extended period can be worked only when there are ingredients necessary to justify the demand for the extended period.
11 date.
In a case leading to short payment or non-payment of tax. That is not the case, Lordship. The owners
So
of
you are,
this-
relying Messrs Cosmic Dye Chemical.
Yes, Your Lordship. This is their own case, Lordship. In their own circular,
So you have relied that also.
Lordship.
We'll consider that only,
Yes, Your Lordship.
not
That-
other cases.
Yes, Your Lordship.
Is it required?
No, Lordship. Other cases are only relating to Lordship time barring. Lordship knows about the Lordship law regarding the time barring. Otherwise, those judgments are not necessary.
After some time.
Again after some time. Yes.
The facts necessary are very limited, man.
Hmm.
There was this POCSO proceeding that was sought to be carried on before the special judge Diffu in absence of a special BP. In fact, an order was also passed. If your lordship will kindly come to Annexure 16 at page 101. We pointed out at paragraph 4, we pointed out,
You are an accused.
yes,
Yes.
the accused has, paragraph 4, the accused has by petition number so-and-so submitted that the learned special PP who was appointed for trial of POCSO cases is suffering from various ailments and since the last many months, learned special PP is not appearing and hence to defer the framing of charges and recording the plea of the accused till a new special PP is appointed. Now, what the learned judge records is this, paragraph 5. The above prayer is rejected at this stage because even though special PP was appointed for trial of POCSO cases, however, due to ailments, he is not appearing for the last several months. However, the learned additional PP who is attached to the court has been appearing on behalf of the special PP. We challenge this that POCSO is a special act and under section 32, the special PP is mandatory to be appointed by the state government. And we filed a criminal petition, which your lordship, your lordship will find at page 104. Page 104. And if your lordship will kindly turn to page 108, paragraph 10. Under section 32 of the POCSO Act 2012, it is provided that the state government by notification in the official gazette shall appoint special public prosecutor for every special court for conducting cases only under the provisions of the said act. And it is further provided that every person appointed as special PP under the said section shall be deemed to be a public prosecutor within the provisions of the CRPC. It is as such seen that it is mandatory that the state government shall appoint a special public prosecutor for every special court. Having recorded this finding at paragraph 12 in the next page, this is the direction now. Page 109. It is a natural corollary that the special public prosecutor should be present in each and every stage during the trial of the offence under the POCSO Act, and it cannot be by any stretch be said that an additional PP may take up his role during the trial of the offence. It will not be out of context to mention herein that under section 31 of the POCSO Act, the provisions of CRPC is applicable to the proceedings before this special court. Therefore, it is concluded that in absence of the special public prosecutor, the order dated so-and-so by which the charge was read over to the accused person and was explained to him, to which he had pleaded not guilty and claims to be tried, is not according to the mandate of law. As such, the order dated so-and-so passed by the learned sessions judge, Karbi Anglong Difu, in special POCSO case number so-and-so, is set aside, and it is further directed that the learned court may proceed with the case only in presence of the special public prosecutor appointed under section 32 of the POCSO Act. Now, your Lordship will find that this order at page 105, this order was passed on 28/10/2025. On the very next day, the Deputy Commissioner, page 111, the mandate of law is section 32 is that the state government will appoint, and that too by notification in the official gazette. The impugned order is at page 111. The Deputy Commissioner takes it upon himself to appoint a special people. In this case, I am not going into the background. This case, I have faced a lot of harassment, my lord, unnecessarily. I am not going into such details. It is at the instance of one of my colleagues that this case has been filed. I am an IPS officer.
Special public as an immediate measure pending the final approval of government in home and public.
And your lordship will kindly have a look at the act. Your lordship will kindly take up the act, my lord. And your lordship will kindly come to first to the definition of special PP, subsection M of section 2. Special public prosecutor means a public prosecutor appointed under section 32. And now if your lordship comes to section 32, (32)(1), the state government shall 32. The state government shall, by notification in the official gazette, appoint a special public prosecutor for every special court for conducting cases only under the provisions of this Act. So this is a special statute, and it prescribes that the state government will appoint and by notification in the official gazette. This section came to be interpreted by the Supreme Court, my lord. In 2009, volume 2 SCC. Why this provision has been specially made has been gone into by the Apex Court. 2009, volume 2 SCC 315.
Then POCSO Act is 2012.
So that I have,
Maybe that is under CRPC.
no. I'm sorry, my lord, this is the citation is. No. I'm sorry, my lord. 2020. I'm sorry. 2020 volume 7 SCC. If your lordship will kindly come to 2027 SCC 130, paragraph 7 onwards, this particular provision came to be interpreted. In our earlier orders, we had emphasized the need to have exclusive special public prosecutors for POCSO cases. Section 32 of the POCSO Act clearly lays down that there shall be a special public prosecutor for the POCSO cases. Subsection 1 is reproducible. The language of the Act leaves no manner of doubt that the special public prosecutor under the Act should not deal with other cases. There is a salutary reason for appointing public prosecutors exclusively for POCSO cases. Public prosecutors must be trained to deal with child victims and child witnesses. They need to understand the psychology of children. They need to empathize with children. They need to know how to bring out the truth from children who are victims of sexual abuse and have to undergo the trauma again while recounting the traumatic experience. The job assigned to the public prosecutor for POCSO cases is a very onerous one, which must be carried out with great care and sensitivity. Therefore, not only is there a need to have exclusive public prosecutors, but there is also a need to develop a training program where these special public prosecutors should be trained to deal with issues which will arise in their courts. These issues may not be confined to legal issues which otherwise public prosecutors may be trained to deal with. The issues may be psychological, health, and other related issues. So the importance of special PP under POCSO Act was gone into. And here is a case, my lord. Firstly, it is expressly without jurisdiction. The DC has no authority to do it. It is only the state government who can do it. And secondly, on the very next day of the order passed by this honorable court, well, on 28th of October, the order is passed by this honorable court in the criminal petition. On the very next day, the DC appoints, and how he appoints is like this one. If your lordship comes back to that order, what he says is, on the recommendation of the superintendent of police. Now, if your lordship turns to page, application page 119, man. Merely this application is filed by the respondent number 4. And on this basis, on the very next day, the DC appoints. Your lordship will kindly see, not even her qualifications are mentioned in detail. How many POCSO cases she has dealt with. Nothing is mentioned.
"24 years practice."
24 years practice. I am much interested and willing to serve as special public prosecutor in conducting cases under POCSO in this and so. For your kind perusal, I have enclosed biodata, etc. And in one day, the DC, and this is a classic case, my lord, where the power conferred on one statutory authority is exercised by another. Your lordship is aware of that settled proposition, my lord. Delegatus non potest delegate. He cannot. When the jurisdiction is conferred on the state government, it is the state government alone, unless the act itself confers the power of delegation. And he refers to a notification in that very interesting one. When people are bent upon harassing, this is how they end up making mistakes. The impugned order, if your lordship will come back to the impugned order, page 111. He makes a reference to a notification of 6/6/2024, as if some power has been delegated. But when you are up to mischief, that is how you get caught. If your lordship will kindly come to that 6/6 notification, which is at page 113.
Six 6/24.
6/6/20. This is for dealing with important cases under CRPC. In pursuance of cabinet decision dated 1/3/2024 in respect of appointment of special public prosecutor under section 24(8) of CRPC 1973, the following procedure is hereby laid down, etc. Next, A, the district commissioners are authorized to appoint special public prosecutor for the purpose of conducting important cases in district judiciary as and when necessity arises with intimation to the government. This is under CRPC. If some sensitive case has taken place in a particular district, a person may be specially appointed. How can the power under 32 of the POCSO Act be exercised by virtue of this notification? And in this case, I have this feeling that perhaps the government will even support us. If such power is conceded to the deputy commissioner, there will be havoc, man. All districts will start appointing as per their whims and fancies. And in any case, this notification cannot be constituted to confer power under the POCSO Act because the statute does not confer the power of sub-delegation. Your Lordship is aware of the law, man. When a statute confers a power on some authority, unless power of delegation of that power is not conferred, it cannot be delegated. So in any case, looked at from either angle, this is not sustainable. I am not placing all those judgments, but if necessary, I'll.
Well, the Lordship has seen page number 112, the order by which the appointment was done. And in fact, my lord, he has also referred it to the government for seeking approval of the government, my lord. At this stage, my lord, I need some time to have the instruction from the government, my lord, what they have done, because the order was issued on 29/10/25. Page
What
112.
is stopping you? And in 2020, 5 years back, there's a order of the Supreme Court which has to be, which is given to all the.
Lordship, I pray for some time, my lord. Let me have the instruction, my lord. In absence of the instructions, my lord, it is difficult on my part to obey, my lord. I need some time for the
Friday.
instruction. Friday.
It can be taken up on Friday, that is not a
Yes,
problem. But the problem is, my lord, the date is.
I think law is very clear.
It is without jurisdiction is void ab initio, man.
Is stopping you. And it's not simply that the completion years of experience as a lawyer. Supreme Court is very clear. You take this also.
Section 30, ultimately, my lord, POCSO, section 32, it also refers that section 2U of the CRPC, the requirement is that only. Let me have the instruction, my lord, under what authority, because the authority of the DC has been challenged here.
No, it's you can just simply you can see you can make out from this order 29/10 100
Lordship.
It talks about that the notification
Yes, my lord.
where it government has permitted
6/6/24.
the district commissioner to appoint
Yes.
in important cases subject to final approval by the government.
Government,
It's a normal circumstances.
my lord.
But when you have a separate clear statute, provision under the statute in POCSO Act, and Supreme Court has clearly laid down why the special PP is to be appointed, what could be rationale and reason behind it. It's not only the experience of that a person should have this psychological aspect of the child has to be looked into. Kind of that experience.
Lordship.
We're not saying that this person who have been a lawyer who has been appointed, we cannot say that. I mean,
Yes.
we are not doubting whether she can be or he can be at this stage
And the,
because we don't know.
In
But
fact-
in the manner he or she has been appointed, he or she,
in
She.
fact, she.
this is something not.
Well, in fact, the annexure 19, it reveals that more than 200 and odd cases, 200 cases are pending. And then trial is not going on because of the ailment of the PP, the special PP, and some requirement is there, and if that
No,
that
that's
request-
why who is there instead of
request
appointing
was made in the month of
appointment by
May.
the district register. Why not?
Lordship,
the
let me
state. That's all.
I pray
At
for a
this
short.
stage, we are not commenting on the, I mean,
Hello.
whether the eligibility or otherwise of the lawyer who has been appointed. Why not on that?
Lordship, on the process,
Friday.
on the authority.
Only difficulty is the next date fixed is 27. Your Lordship will for the timing stay it because it is expressive without jurisdiction and anything without jurisdiction is void ab initio. So
Where is 27 is what?
Today,
27/11.
today is 25th.
Ah.
I need at least 2-3 days time, my lord. Let me have the instruction because he has referred it to the
Friday
government,
is
what the
what?
government is there.
Friday is 28th, man.
Necessary, this should be. Take it up tomorrow.
I'll try, my lord. I'll try. Kindly, if not,
Instruction in the sense, what is it? You advise the government, you have to appoint.
He
That's all.
cannot-
Government has to appoint.
What instruction, my lord? It
I'll
is expressly
indicate,
in our
I'll-
jurisdiction.
I'll
then,
indicate.
my lord, there is no necessity to hear the respondents.
Huh?
If no instruction is required, as has been submitted by my learned
How
senior.
can, how can he
No, no.
get an instruction that this has jurisdiction?
Otherwise, unnecessarily, we'll have to stay the proceedings. Which may not be.
Let it have tomorrow, let it have tomorrow, my lord. Kindly
25.
take it up 26. Tomorrow is the 26th, at
26
2,
we'll take it
at 2.
tomorrow.
Tomorrow at 2, my lord.
At two, we'll take it.
Tomorrow.
Tomorrow.
I must get some time to have the, at least under what authority the DC has done, let him say, my lord. If he says that I don't have, that is what he has. Then Lordship will pass the order. Something may be there, my lord,
Mr.
without asking them.
Chaudhary,
it
let
is
us
difficult
senior
on my
counsel,
part.
assisted by Mr.
M.A. Chaudhary.
Learned counsel for the petitioner. Next parent. The challenge made in this challenge made is to the order dated 29/10/2025 by the issued by the passed by the Deputy Commissioner Karbi Anglong Madipu, whereby one Mrs. Lolita Rengma, Advocate Dipu, has been appointed as special secretary to conduct cases under POXO Act in the Special Court of POXO District Judiciary. Special Judge within bracket POXO. Amar Dipu. List of. It is the contention of land counsel for the land senior counsel for the petitioner. That under section 32 of the POXO Act 2012. It is the state government who shall, by notification in the official gazette, appoint a special public prosecutor for a special, every special court for conducting cases only under the provision of the Act. He submits that the Deputy Commissioner Karbi Anglong has transgressed his power and exercises illegally, which is not conferred upon him. Mr. Referring to the order of the Supreme Court in the case of IN alarming rise in the number of reported child rape incidents. Admits that the Honorable Supreme Court has already clarified the law, the provisions of appointment of special public prosecutor under section 12 of the 32 of the POXO Act Mr. So we'll not issue notice today.
Lordship is fixing it tomorrow. I'll
Tomorrow, huh?
Lordship.
Dinner. Learned senior government advocate
1, 2 and 3, my lord.
submits that he may be granted a day's time to obtain instruction as the appointment of the special public prosecutor is is evidently by the Deputy Commissioner Karbi Anglong, right? Whereas the power to appoint a special public prosecutor under section 32 of the POCSO is with the government. It is the fact, and I'll just considering the next one. Considering the issue involved, let the matter be listed on 26th
6th.
at PM for consideration.
Lordship.
Your lordship is fixing it at 2 p.m.
2 PM. We'll consider.
Obliged.
Normally, we don't want to scuttle, stay the proceedings.
No,
That's the reason.
Lordship. Oh, Lord.
Even again.
Please, Your Lordship.
Yes.
Lordship, kindly adjourn us for today.
Hmm?
Kindly adjourn us for today.
Why?
Actually, I came to know that my senior counsel is not feeling well.
Where he has gone?
So,
What is the matter? You are good at matter. What
actually,
is the matter?
Land acquisition matter.
Okay, so
Lordship, I don't.
we'll take it up at 2 o'clock. 2 o'clock. You are good at matter. Prepare it. We have enough time. 2 hours you have.
Lordship, actually, it is a very old matter. I don't have any idea about it.
You give the second file. You have the file?
Yes, Lordship.
You have the file.
Yes, Lordship.
2 hours. You go to library and read it.
Lordship,
Read it.
please give us a
Hmm?
date, please. Give us another date.
No
please.
adjournment. You try. If there is difficulty, we'll see. 2 o'clock. You read it. Go to the library or the bar and read it.
Okay, sir.
8-2. Hmm. Yes, I've heard you. It's okay. We'll hear the other side. Where it is? Huh?
We have informed him. He's coming. Lordship. We have informed him. Lordship, I
Anything you want?
just one judgment, Lordship. Lordship
Why
has
so
asked.
many judgment? You have
Lordship,
annexed so many.
Only one
judgment.
judgment. Lordship, other judgments are only relating to barred by limitation, Lordship.
We are
on the-
not considering all the judgment.
Yes, Your Lordship.
It's unnecessary.
Lordship, unnecessary. So I'm giving only one judgment, Lordship. Supreme Court. Directly on the point.
We are not saying that you cannot rely.
Yes, Your Lordship, but that is unnecessary.
Because we find it to go through all the judgments,
Yes, Your Lordship.
it's a taxing for us. Physically, mentally, most importantly, the time.
That's why, Lordship, there
Because
is,
every judgment it takes 30 to 40 minutes to 1 hour to
Yes.
go through.
Lordship, it's a very small
So
judgment, 3 pages.
all weeks goes on. And we find that, I'm not saying you particular case, and we find that ultimately after going all the judgment, we find that only few of them are applicable or referred.
Yes, sir.
And if you don't refer it also and distinguish it, then again, lawyers will say that he has not
Okay.
considered.
That's why, Lordship, I'm relying only on one judgment,
So
and
it
that's a
takes
3-page
10
judgment.
10 to 15 days, 1 month to go through.
Yes, Your Lordship. I'm relying on only one judgment, Lordship.
Just put it here. Then we'll assembly at two. Assembly. Well,
Yeah,
so there's no other method, so at two.
at two, Lordship.
Well, the other party, we do not see whether lordship, but as they have not come, if your lordship dispose of the matter, I am ready. But other party is not here.
Who is other party?
Other party, my lord, the respondents, that is numbering 12. State is a party. Besides state, there are 11 parties.
Notice had been served.
We have taken this long back, but I have not.
Notice is served in 2016 matter.
Yes. So I am ready to argue the matter, but we have taken steps, but it is. Yes, this is, it's a.
Where's the appeal order?
Yes, 35.
Where is the respondent?
Respondents in the first 3-4 pages. Page number,
It's a writ petition.
yes.
Huh?
Because the special appellate tribunal has not yet been constituted in Assam. So, after the order passed by the special judge, the High
What is
Court
that order?
that is page 34. Operative portion starts from page 35. As the steps have been taken long back, my lord may resume that notice is served and order may kindly be passed.
Yes.
Lordship is ready to hear.
Yes, court finds that there's no case against under Land Grabbing Act. All right.
Yes.
So this has to be tried under IPC 447/506 and 427. It was sent to Chief Judicial Magistrate.
No, thing is this. my
What's
lord.
wrong?
Let us
What's
see
wrong
the
in it?
preamble of the Act. Assam Land Grabbing Prohibition Act 2010.
What it is?
It is in the Act. So, two 2010, Assam Land Grabbing Prohibition Act 2010. Also may say preamble, whereas there are organized attempts on the part of certain lawless persons operating individually and in groups to grab either by force or by deceitful means or otherwise lands, whether belonging to the government, a public sector undertaking, a local authority, a religious or charitable institution, or endowment, including a waqf or any other private persons, or a site of historical monuments, etc. And whereas it is necessary to arrest and curb immediately such unlawful activities of land grabbing, and whereas public order is adversely affected by such unlawful activity of land grabbers, it is here enacted. Now, notes of the preamble. The occurrence of land grabbing by a section of anti-social in the city of Guwahati as well as in any other parts of the state has become so common a factor that it ultimately compelled the government to seek redressal by of enacting an act in the name of and name and style of Assam Land Grabbing Prohibition Act 2010. The act has been published in the Assam Gazette, that is so. As reported, the act received the assent of President on 28/10/11, unless otherwise provided, an act comes into force from the date of assent or approval of the appropriate authority. The present act contains provision that it shall come into force on such date as the government may, by notification in the official gazette, appoint. So the agreed person or concerned shall have to wait till the appointment date for their rescue. Anyway, this is a piece of legislation which is undoubtedly of great public interest. Now, Lordship, here the land includes private person's land. So I have 5 bighas of land. The respondents 1 to 11, they are antisocial elements. They grabbed my registered 5 bighas of land in my absence. So I filed the FIR before the authority. And the police found that it is organized crime. Case was registered under IPC as well as Land Grabbing Act. Now, if the case is tried by a criminal court, then what will happen, my lord? Criminal court, I am saying the procedure, criminal court, at first, they will issue summon to the accused persons. They will come, may be released on bail. Thereafter, date of charges should be fixed. Then evidences that several dates should go. In this manner,
That we cannot help it out.
my lord,
That's the procedural hazards.
yes,
You may say, we cannot help it out.
no, that is.
What's wrong in this order?
That is this, no, my submission was that section 3 and 4 of the, 3 and 5 of the Land Grabbing Act, that act provides some quick relief. Because if the criminal court convicts those persons in the long run, they cannot pass any order for eviction. They will file appeal before the learned session judge. Then again, they may come to High Court. In this manner, my lord, 6, 10, 20, 12 years may go. So,
It's only 11 years,
Ma?
9 years.
9 years, 10 years. So,
It's already 9 years. This matter is already 9 years.
9 years
Then-
old. But this will take, that is why our submission is that let it be tried under Land Grabbing Act. Because
How?
police has also filed charge sheet under this Land Grabbing Act. Here, let me show the charge sheet, can you see, page 29. Of course, there is no bar in the criminal code. But thing is this, that will kill the time, and till then, my lord, these persons who has purchased this 5 bighas of land in exchange of valuable consideration, he will be out of receiving any benefit from his own purchased land. They will get benefited. So, here Lordship may kindly see page 27. This is the FIR. Subject prayer for taking action under section 3, Assam Land Grabbing Prohibition Act. So, he has given the names of these persons, saying that they have encroached my land, built 2 contemporary houses in the early morning of 26/12/2013 with the evil intention to capture my land. So, their intention is to capture my land.
See, this order is passed by
Special tribunal.
Is it a special tribunal?
Yeah, special tribunal, Land Grabbing Act. But this, the seal has been put additional district judge FTC, but it should have been by this special tribunal, a special tribunal. Then appeal will be filed under section 13 to the special tribunal.
No, this tribunal has found that no case under section 3 and 6 of the Assam Land Grabbing Prohibition Act is found prima facie established.
No, kindly see now page 35 bottom. After having completed the investigation, police however laid charge sheet against the accused, namely Julhasuddin and 8 others, to stand trial under section 447, 506, 34 IPC, read with section 3(6) of the Assam Land Grabbing Act. So if this 3 and 6, and I think 3 and 5 would be better. So if the case is tried also under section 3 and 6, I will get remedy, quick remedy. And unlike
Which remedy? You just, what's wrong here? You just read page 37. Just because police has filed charge sheet,
Yes.
it's not that it should be tried.
No, plus 37.
So no case under section 3 and 6 of Assam Land Grabbing Act is found prima facie established.
How? So
It's
that,
by the tribunal. We have to challenge this.
no, I have challenged this.
Ah,
I have challenged this in this.
what is
petition.
ground? What's wrong here? They found that
Wrong
there's
means,
a
my
case.
lord, here in this instant case, principal offence has been committed by the accused persons in the nature of criminal trespass, criminal intimidation, etc. That is totally incorrect. Because they have also constructed houses. Their intention is to capture my land permanently. Otherwise, criminal trespass for the purpose of plowing or for the purpose of showing some intimidation,
This is by the additional district judge, FTC.
FTC, that he is the tribunal, special tribunal.
Hmm.
The act says district judge is a special tribunal and a district judge, this special tribunal also includes additional district judge and session judge. They are equal in power, accepting some administrative matter. District judge is
So
the,
it lies.
my lord.
226 lies or what?
Yes, lies because when there is special appellate tribunal, writ would not lie. But in Assam, there is no such special tribunal. Till today formed. That is why writ would lie. If
So-
your lordship is, no, that
A special tribunal doesn't have
Special-
the power to try the criminal
the
offences.
special judge, a special judge. A special tribunal is the additional or district judge.
Hmm.
A special tribunal is the appellate authority. The special judge or a special, that kindly see page 13, I think, page is section 13. Here,
PP, can you hold the PP? Why this?
13, here, any person aggrieved by the judgment and order not being the integrity order of the special tribunal. So district judge is the special tribunal and may prefer an appeal before the special court, or any question of law or fact. Now, this special court or special appellate court is not yet constituted in Assam till today. So people cannot be remained deprived from lawful remedy. So when one order is passed by the special tribunal, that is, he is the final authority, he would be the final authority. So when the special,
So according to you, this impugn order is passed by the special tribunal.
Yes,
So appeal lies under section 13.
30.
Then why not 227? Why 226?
No, 227, that is because there is appellate provision. There is appellate
What
provision.
appellate provision is there because there's no special court has been, according to no special court has been constituted.
Yes,
Otherwise, appeal lies.
appeal lies.
Hmm?
Yes,
Agreed by judgment and order, not being an interlocutory order of the special tribunal.
yes.
Are you sure?
Yes, I am sure.
It has not been constituted.
If within 1 month or 2 months it is constituted, I have no idea. Before that, it was not constituted.
That was the statement by whom?
No, that this question was raised at the very earliest, and we have satisfied the court. And at that time, I think PP was also present. He also said that yes,
It's 2016. No special court has been constituted here, appeals against the order of tribunal under Assam Land Grabbing.
yes,
It's in 2016.
yes.
We're in 2025.
But thereafter also some other cases have been also filed. Similarly, writ petition has been filed. And the government advocate said, PP said that
There it is.
no, in this case, that order is sufficient, but in other cases, I am saying, and if for your lordship satisfaction, your lordship may ask one government advocate or a PP whether such a special tribunal, a special court has been constituted by the government through gazette notification, that may be asked for. But so far my knowledge is concerned, till today, no such court is established in Assam. The Odimpoon order is wrong because in the purpose of the enacting this law is vitiated. 10, 12 years they will take, and my land would be under their possession. They will enjoy the benefits of that land. And I, being the bona fide purchaser through registered sale deed, I have been denied. So Land Grabbing Act was enacted to give speedy and early remedy. But if the case is tried by criminal court, then it's long way. And in the long run, my lord, if they are convicted even, but I will not get my land.
It's not the question of you get the land or not getting the land. See, we are more concerned about the
No,
procedural law.
One thing, Lord, so let me clarify. It is not an ordinary case. It is to be proved by them that they are the owner of the land. Burden lies on them, not on me. I have given my registered sale deed. So that is the prima facie proof that.
No, we're not on that, on the merit. We're saying that we're on the concern on the, now at present we're concerned on the procedural law.
I am saying because your lordship said that a civil court over that civil court will decide whether the petition.
Who said that civil court will decide? Nobody said so.
The criminal court will decide. Then the civil liability will come. Civil court will frame issue that whether I am entitled, I am the owner, landholder.
Sir, why you are trying to understand? I said the issue is when there's an appeal lies, we cannot entertain your writ petition,
No, that,
right? You are admitting that under the provision which you are seeking conviction or decision by the court
yes.
against the respondent, private respondents, right? This order refusal to and finding that there's no prima facie case established against the appeal lies under section 13. Yes.
My lord, actually, my lord, it is a my lord, WPC, my lord.
2016 matter.
Yes, my lord. My lord, in WPC matters, my lord, the state prosecution is not allowed to, my lord, appear.
Who said? Who said so?
My lord.
There may be nomenclature may be different.
But my lord, government used to appear, my lord, in the matter, my lord, government advocacy.
Government is not party, it is by the public prosecutor in this matter.
My lord, in those cases, my lord, especially my lord WPC and my lord, that is the WP.
Don't go by the nomenclature, sir. From day one, learned additional public prosecutor appeared.
Land Grabbing Act. No, special tribunal গঠনে হওয়া নেই দেওয়া হয়। Land Grabbing Act. Till today, no.
See, do you have any idea whether the the special court has been constituted under the Land Grabbing Act?
Under the Land Grabbing Act, my lord. But
From
then,
2016, you are saying that you have not constituted.
my lord, you give us only one date, my lord. My lord, in the meantime, I will take a my lord written instruction in this regard, my lord. And also, my lord, communicate the thing, my lord, because my lord WPC, the senior government advocate. And in the meanwhile, I, on behalf of my lord, that is the state prosecution, we will take instruction, my lord.
You are public prosecutor.
Yes, my lord, additional PP, my lord. Only one day, my lord. I'm praying for a day, my lord, because 2016 matter, my lord. And as on today, my lord, now the thing is that, my lord, the PP are not entitled, my lord, because of that, my lord. Otherwise also, my lord, as per the direction of this honorable court, I will take the instruction. And my lord, same also maybe, my lord.
Party, your party here, the challenge is against the criminal, this thing, code
Yes,
of
my
the
lord.
tribunal.
My lord, that's true, my lord. There is no, my lord, that thing, my lord. But recently, my lord, that is, my lord, we are only appearing on behalf of
The
the
state of Assam represented by Public Prosecutor, Guwahati High Court, Guwahati.
my lord. My lord, we will,
Parties are also not made like
we
this,
will
huh?
take instruction, my lord. We will take instruction, my lord. Only one day, my
There is
lord.
nothing
Allow
in record
us.
to show that whether the service is complete or not. How these records has been maintained. Should go, so and so, so and so. Who has filed in Bakhalatnama? 1 to 12, 11. No, no. Heard Mr. M.U. Mohammed, learned counsel for the petitioner. This petition
Service
is filed against the order dated so and so, for the page 36. Was by the additional district judge within bracket FTC come special tribunal,
No, there should be a special tribunal, yes.
special tribunal, Darang district, whereby the case, the so and so case is disposed of, demanding the
Instruction to local
learned CGM for trial under for offense under section so and so IPC for 47,506 something, 427,35 IPC. And having found that no case,
My lord, ke boisso, my lord. Additional.
no case under section 3/6 of Assam Land Grabbing
Prohibition
within
Act.
bracket Prohibition Act 2010 is prima facie established. Mr. Admittedly, no, it is noticed that any order, judgment and order passed by the special tribunal, no, an appeal against the judgment and order of the special tribunal would lie before the special court under section 13 of Assam Land Grabbing within Prohibition Act 2010. Next paragraph. Records indicates that as on today, the record indicates that, not as on today, records indicates that the state of Assam has not constituted special court under section 14 of the same Act of 2010. Mr. None appeared for the respondents, including the State of Assam, initial, however, on the request of this court, Mr.
K. Bushra, my lord.
A. Bushra, learned additional PP had appeared. However, submits that in view of the submission, however, submits that he will not be authorized to appear in the case which is numbered, which is in a writ petition,
Right.
even if it pertains to criminal proceedings. Although this court finds strange to such submission, since he is appearing for the first time in this matter, a week's time is granted to obtain instruction as to whether any special court has been constituted under Section 4 of the Assam Land Grabbing Prohibitions within Provisions 2010. It is expected that the learned public prosecutor shall appear in this matter on the next date. Just after a week.
My
We'll see.
Deeply obliged, my lord.
If we find
Take
that,
the instruction, my lord.
Date may be fixed.
if we find that it has been already constituted, we'll dismiss your petition.
Date may be fixed, my lord.
That is your lordship discretion, but
It is you to be vigilant also. Every case cannot be filed under 226.
no, there are so many cases pending in High Court.
So what?
And this is the first time your lordship is going
We'll
to this
finish it off.
227 or 2, but all cases are filed.
At best, if there is no, if the special court is not
No,
constituted.
that court is there, we have no,
26, what?
we have no place here.
26 unnecessary.
Yeah, that will
We
be
cannot
unnecessary,
dilute the
provided the constituted.
Sir, we cannot dilute the procedure
Right.
or the law. They have to be very clear, at least the procedural part. Yes.
My lord, date may be fixed otherwise. My lord, whether my lord, a date may be fixed, my lord.
3rd December.
3rd December, deeply obliged.
Yes.
May I please? Lordship, first my submission is that there is an alternative remedy. Alternative remedy is available to the petitioner. Lordship may come to page 145.
145. Yes.
Paragraph 2.
Order in original, yes.
Any person, Lordship, what?
Para?
Paragraph
145.
Yes, page 145, paragraph 2.
Ha.
Any person deeming himself, Lordship, what? On the top it is in Hindi, in next summarize in English, Lordship. Any person deeming himself aggrieved by the order.
You read in Hindi. It's been long time. Read in Hindi.
इस आदेश के से असंतुष्ट कोई भी व्यक्ति इसके विरुद्ध आयुक्त अपील केंद्रीय जीएसटी केंद्रीय उत्पादन शुल्क एवं सीमा शुल्क 3rd फ्लोर माचकुआ रोड केदार रोड भवन जीएसटी गुवाहाटी को प्रारूप एसटी शुल्क मांगे गए में 4.7.5 के भुगतान कर अपील कर सकेगा। Then जब शुल्क विवादित हो या शुल्क को जुर्माना विवादित हो तो केवल जुर्माना विवादित हो अपील पक्षकार के आदेश के प्राप्ति के तारीख के शुल्क न्यायालय के 2 महीने में so it is not Hindi is not so clear also. May I read in English also below? The person deemed himself aggrieved by this order
may appeal against the order to the Commissioner Appeals, Central GST and Excise Custom Guwahati, third floor, GST Bhavan, Kedar Road, Machkua, in form ST4 in duplicate on payment of 7.5% of the service tax demanded where the service tax and penalty are in dispute, or penalty where penalty alone is the dispute within 2 months from the date of receipt of the order by the party. It should be bear a court fee of stamp of ₹2. So there is an alternative application remedy available to the petitioner. They can file appeal if they are aggrieved by either by the service tax or by, because in this case, Lordship, they paid the service tax and interest. Only they are aggrieved by the penalty. So they may file appeal before the authority. Lordship, recently Supreme Court.
The penalty can be imposed
Yes, it can be imposed.
under section 78.
78.
How?
Lordship, I'm coming. Lordship, before Lordship, that Lordship, on 12th of November, this month, Lordship may come to paragraph 9.
9.
While deciding whether to entertain a petition under Article 226, bearing in mind the precedents in the field, a reed court ought not to additionally notice the forums designated by the statute for the litigant to approach. This is a necessary because alternative forum that is provided by the statute has to be one which can dispense speedy and efficacious relief. However, as the present case, if the statutory designated alternative forum appears to be in the High Court itself, whose jurisdiction under Article 220 is involved, and not in any ordinary statutory function, tribunal refusal to entertain the writ petition should be the rule, and entertaining it an exception. We may profitably refer this context to the constitutional based decision in Than Singh Nathwal. This court has occasion to lay down a principle of law which is statutory and not to be found in any other previous decision rendered by it. The principle plainly is that if an remedy is available to a party before the High Court in another jurisdiction, the writ jurisdiction should not normally be exercised on a petition under Article 226, or that would allow the mandatory setup by concerned statute to be bypassed. The relevant passage from the decision is raised under as follows. The jurisdiction of the High Court under Article 226 is cast in wide terms, and the exercise thereof is not subject to any restriction except the territorial restriction which are expressly provided in the article. But the exercise of the jurisdiction is discretionary. It is not exercised merely because it is lawful to do so. The very amplitude of the jurisdiction demands that it will be ordinarily be exercised subject to certain self-imposed limitation. Restored to that jurisdiction is not intended as an alternative remedy for relief which may obtain in a suit or other mode prescribed by the statute. Ordinarily, the court will not entertain a petition for writ under Article 226, where the petitioner has an alternative remedy which, without being unduly onerous, provided an equally efficacious remedy. Again, the High Court does not generally entertain upon a determination of question which demand an elaborate examination of evidence to establish the right to enforce which the writ is claimed. The High Court does not therefore act as a court of appeal against the decision of a court or tribunal to correct errors of the fact, and does not assume jurisdiction under Article 226 tench upon an alternative remedy provided by the statute or obtaining it relief, where it is open to the aggrieved person to move another tribunal or even itself. It is another jurisdiction for obtaining redress in the manner provided by a statute. The High Court normally will not permit any entertaining a petition under Article 226 of the Constitution. The machinery created under the statute to be bypassed, and will leave the party apply for it to seek restored to a machinery to set up. The next paragraph, paragraph 11. Since the appellant has a remedy by way of reference before the High Court against the order dated so and so. Said we do not consider refusal to exercise discretion in favor of the appellant to be so fundamentally incorrect and in preference is warranted. Apart from the majority view, the previous constitutional bench in A.B. Venkateswaran, so and so, paragraph 14, we must express our dissent from reasoning by which the learned judge of the High Court held that the writ petition was absolved from normal obligation to exhaust his statutory remedy before invoking jurisdiction of the High Court under Article 226 of the Constitution. If a petitioner was disabled himself from availing himself of the statutory remedy by his own fault, in not doing so within the prescribed time, he cannot certainly be permitted to urge that as a ground for the court dealing with the petition under Article 226 to exercise his discretion in his favor. Indeed, the second passage extract from the judgment of the learned C.J. Mohammed no case in which the reference to the right to appeal being lost, though not fault of his own, emphasizes this aspect of the rule. The essence of this court is the opinion that once the petitioner has due his own fault disable himself from availing the statutory remedy, the discretionary remedy under Article 226 may not be available. Although there is no period of, then Lordship, period of limitation has been considered. So in my humble submission, Lordship, when efficacious remedy is available under the statute.
Is under statute under?
Yes,
section?
Lordship, in the Finance Act 1994.
Under section?
Lordship, I am coming. Section 84, Lords.
Huh?
Section 84.
Of Finance Act.
Finance Act 1994, Lords.
Huh?
Finance Act 1994.
Section 85.
84, 85.
Not 84, Lordship, 85.
85.
84 is on his own motion.
This is kind of revision. 85. So this is by
the commission, this is by additional commissioner.
who is subordinated to
Commissioner. Commissioner
principal
appeals.
commissioner.
Appeals.
Huh?
Commissioner appeals.
No. Any aggrieved person aggrieved by judicial order passed by executing authority subordinate to the principal commissioner of central excise.
Yes.
Additional commissioner is subordinate.
Yes, subordinate to.
Subordinate.
This provides 3 months. Why you have provided for 2 months? Okay, payment of Or 2 months from the date of issuing. Then
Yes, your lordship. Lordship, I have already submitted my judgment. Lordship, first my submission would be, if he has completed, lordship, may I start my submission? If finished his submission, I'll start my submission.
you have completed your submission.
Lordship, I'll start my submission
At this point,
on this
Lordship,
point.
on this point, my submission is,
Yeah.
Lordship, firstly, Lordship, when the matter was first taken up, Lordship, on 7th of 11/2022, when the interim order was passed and notice was issued, Lordship, the question of maintainability was not opened. Secondly, Lordship, they have filed an affidavit without raising all these points. They have never not raised a single point on maintainability of the petition, that it is not maintainable and we should have gone to the alternate remedy. After the matter has been admitted, it is a lordship admitted position of the, after the matter has been admitted and fixed for hearing, they cannot raise the question of maintainability at this moment after the hearing is at the hearing stage. Lordship, thereafter also, Lordship, I have given a paper book, Lordship, wherein I have submitted the judgment of Whirlpool. Lordship, why I am submitting the question of Whirlpool? Because I have raised the question of
1998.
Yes, your lordship. Lordship, I have shown the judgment of Whirlpool, and there is another judgment, Lordship, Manoranjan Chakravarti. That is also of Supreme Court, that hails from the state of Tripura, which says high-handed order. Lordship, this is a high-handed order. If it is a without jurisdiction order, this person has no jurisdiction to assess me for penalty. He is levying tax on me and he is appropriating this one. And Lordship, penalty, he has no jurisdiction to levy penalty on me. And thirdly, Lordship, it is barred by limitation. Lordship, I have already shown that since it should have been passed within a period of 30 months, they have invoked the extended period of jurisdiction. That is why I refer to the circular, which Lordship, that extended period of jurisdiction limitation that they have invoked, that cannot be invoked in this case because this case does not fall under that. And that is why, Lordship, I have given the judgment of the Supreme Court, which says what is the meaning of the extended period of jurisdiction. In their circular only, they have given the copy of this judgment, Lordship. I had given the circular with paragraph 3.2 and 3.3. This is their own circular. They say that if the tax is paid, they cannot, Lordship, extend the period of limitation.
This is what?
this is our High Court judgment on point of alternative remedy.
What is, Lordship, I am doing a hearing. Lordship, GNRC, they have already appealed to the division bench and the division bench has already held. I am not on this, Lordship. Lordship, may kindly see the circular, Lordship, which I have referred to. GNRC division bench judgment. There is a stay on this judgment. And that was on altogether different point. Circular has also not been shown in that case, Lordship. GNRC. Circular. I can show hundreds of judgments where the court has exercised its limit. Article 226. Lordship, after this, there was a writ appeal. The writ appeal has been disposed of. Writ appeal has been disposed of.
Huh?
Writ appeal has been, after the Lordship, the single bench judgment of GNRC is being shown. Lordship,
No, this division bench,
division bench, okay, sure.
which has been affirmed.
Yes, sir. Paragraph 14 onward.
This was against the rejection of refund claims. Rejection of refund claims.
Ah.
This is Lordship time barred assessment. And Lordship, hundreds of cases are there, Lordship, which has been decided. Recently, the single bench judgment of Lordship Justice Devshi Barua was there. All over India, Lordship, the rule is followed. If it is barred by limitation, then the High Court is the only
I think
jurisdiction.
that in that case, they may not have raised the issue.
They have not raised this issue, Lordship.
In other cases, the maintainability.
Lordship, maintainability, Lordship, whenever the cases are filed against the order of assessment, they raise the maintainability issue. Lordship, in this case, they have never raised. This is the first time they are raising the issue.
No, in other cases.
In other cases, they have raised, Lordship, and the court has dealt with it. Lordship, I can show from the two judgments which I rely on in respect of Lordship Supreme Court and one judgment of this Honorable Court that alternate remedy can be a bar, but it is not a rule, Lordship, not always.
Yeah, it's there.
Lordship, when the matter
It's
is
always there.
barred by limitation, when there is a barred by limitation order is there, then the High Court is the only jurisdiction, Lordship. Lordship, may I kindly see the judgment of Whirlpool at page 63 first. My paper book, Lordship. The judgment of Whirlpool at page 63, the paper book which I have given of written submission. Para 15, Lordship.
We'll see it.
1-5.
Okay, we'll consider.
Yes, Your Lordship.
But admittedly, there's a provision for appeal.
Lordship, there is a provision, but when it is barred by limitation, Lordship, when it is barred by limitation, Lordship, what is tax, Lordship? Lordship, I'll take just Your Lordship's 2 minutes. What is tax, Lordship? Tax is, I have done something, I have given my services to somebody. Service tax. I have given my services to somebody. Now it is between me,
It's okay.
me and that person. If the government has to come, that has to be within jurisdiction.
Lordship, there
What
is no,
about on merit?
there is no bar in raising this question because this is a low point. It can be raised anytime. Lordship.
For the appellate
Yes.
authority?
And regarding merit, Lordship may please to see the notice.
Ah.
Why notice has been issued. That has been explained at page 138. Under the heading contravention and jurisdiction for invocation of extended period of limitation. Page 138. The notice.
138.
Lordship. Under the heading contravention and justification for invocation of extended period of limitation.
Demand.
Yes.
Huh?
demand comes suppose not.
Page where it
Page
is?
138.
Contravention, justifying invocation, extended period of limitation.
It has been explained, what's it then? Page 162 in the order in original, paragraph 11.
One 160.
Page 162,
Hmm.
paragraph 11.
Yes.
On the facts and documentary evidence stated above, I am convinced and hold that the said notice has contravened the provision of section 66B, 68, 69, and 70 of the Finance Act 1994, that which Rule 6 of the Service Tax Rules 1994, by resorting to deliberate separation of value of taxable service received by them during the material period with the intent to evade payment of service tax and cess totaling to rupees so and so, which is to be recovered under section 37 AVD along with the interest under section 75 from the noticee. The said noticee by their act of omission commission have rendered themselves liable to penal action under section 77 and 78 of the Finance Act. And paragraph 11.1 regarding invocation of extended period of limitation, I find that the said noticee suppress the taxable value in the ST3 return in the regime of self-assessment. The onus lies on the party to declare the tax value applicable service tax in their periodical ST3 returns. The misdeclaration of the taxable value by the said noticee come to the knowledge of the department only after receipt of the information from other source. Had it not been for the data received from the income tax department, the suppression of the taxable value by the said noticee would not have been detected. The said noticee willfully suppress the taxable value with intent to evade payment of service tax. Therefore, I hold that the service tax not paid by the said noticee is recoverable from the invoking extended period of limitation under section 73(1) of the Finance Act. Further, I find that it is settled law that where demand of service tax has been held to be sustainable, a tax defaulter is liable to pay interest at applicable rate in term of section 75 Finance Act 1994. I find that the impugned SCN dated 22/10/2021 proposed for imposing penalty on the noticee under section 78 of the Finance Act. I am of the view that the section 78 of Finance Act is coterminous with the proviso to section 73(1) of the Act. I am of the view that the legal requirement for invoking provision under section 73(1) if for recovery of service tax beyond the normal period of limitation and the legal requirement for invoking 78 for imposing penalty on the defaulter are identical. Therefore, I am of the considered view that once the provision of section 73 of Finance Act has been held to be sustainable in the fact circumstances, the present penalty under section 78 is impossible in the instant case. I hold accordingly. So, chapter 5 of Finance Act, and let's see, because it after progression of GST, this chapter was taken away. Let's see, it was repealed. But so and so under section 173 GST Act, but section 174(2) empowers the undersigned to adjudicate the case demands in the of the tax payable but not paid by any region during time prior to 1/7/2017, subject to previous stipulation under its Finance Act 1994. And this was upheld by our High Court Lords. The department is under section 174 has power to block Finance Act 1994. And let's see next page 8, page 163, 12.1. I partially confirm demand of service tax including cess amounting to rupees 72 lakh so and so out of total demand of rupees so and so for the financial year 2016-17 in terms of section 73(2) of the Finance Act for the region is discussed in para 3.4 and 10 supra. I ordered interest of the above confirmed. Then 12.3, I impose penalty rupees 10,000 under section 77(2). Then 12.4, I impose penalty of rupees 72,73,000. Then Lordship, important, I order appropriate the service tax amounting to rupees 73,20,000 and interest amounting to rupees so and so was already paid by the noticee towards their liability. Then 12.6. However, the notice is given option to pay reduced penalty equivalent to 25% of the penalty amount imposed under section 78, subject to condition that the noticee deposit the amount of service tax and cess confirmed under section 73 of Finance Act 1994 along with interest in term of section 75 PVD and reduce penalty under proviso to section 78 within 30 days of the date of receipt of this order. But they fail to pay and they challenge before this honorable court.
So what is this 17.6?
Yes, Lordship.
How much he has to pay? in
Now,
that
Lordship,
case?
because they have failed to pay, so now the entire amount.
Now,
of
in
penalty-
this case, how much they have to pay?
Lordship.
73.
72,73,000 in and 10,000 under close 12.3.
In addition to 73,000, which he has already paid.
No, they've already paid the tax and interest.
Hmm.
Lordship, this and another Lordship presumes can be found.
Penalty is 73 lakhs.
Yes, it is there. Lord. Equivalent amount to the tax. Lordship.
So option was given to
Them,
pay
Lordship,
25%.
but they didn't avail.
penalty.
Lordship, in case I will pay. I have already paid, Lordship. The option does not come. It's a standard format which is there. They put in every order. In this case, it is Lordship has no value. This line. They say if you pay, but he has already said that you have already paid.
No, it's
No.
not that. This is your tax, service tax, which you have already paid.
Already paid long time back.
Ah,
Before the
70
issuance
no,
of surplus notice.
72 something. What is that? 72 lakhs 33.
Before even
Or is it
issuance of
something,
surplus
and
notice.
with the penalty. No. With what do you call it? What is this 6 lakhs?
Interest.
Interest, sorry. That you have already paid. That
That's
has been appropriated only.
2017 itself.
That is
was paid.
already appropriated.
Yes.
But 73 lakhs is penalty only.
Only penalty, Lordship. they are
Under
giving.
section 78.
That is what I am saying.
Yes, Lordship, this is the.
Under what condition you can charge, impose
Lordship,
penalty?
because they fail to disclose, because the service tax is self-declaration statute, it was self-declaration. It was their
But
duty.
once they paid,
Lordship, that's why Lordship may please to see paragraph 11. It's clearly stated that they have suppressed the facts. Lordship, unless EPB didn't got the information from income tax department, then why they have admitted their liability? Then why they have paid, Lordship? They paid the tax. That means they have suppressed the service tax from the department, Lordship. That is the reason they paid. When we have so-called notice, then they paid.
Lordship, before issuance of surplus notice 2017. Surplus notice is 21. I have paid in 2017. Entire amount.
What's the matter relating to 2016-17? They have suppressed the facts. They have not filed their ST3 returns. They didn't disclose all these materials before the department, Lordship. When we got information from the income tax department, then Lordship proceeding was initiated. Many letters were issued to them, Lordship. Let them deny that we have not issued any letter to them. Then why they paid the tax?
Paid the tax not after issuance of notice. Before issuance of notice, Lordship.
Even the Lordship.
Even anything.
We have made inquiry.
On time.
Lordship, we make inquiry. When they realize that they have committed mistake, then the amount was paid.
after the notice,
No, before the notice.
before the notice.
Lordship, we have issued many letters to them while the inquiry was going on. Lordship, want to see?
Anyway, ultimately it has been paid.
But that tax has been paid. That is admitted. That's why it is
Ah.
appropriated.
Hmm.
Now, Lordship, under section 78,
Hmm.
whether imposition of penalty is proper or not.
Hmm.
My first submission is that there is an alternative remedy. They can approach the Commissioner appeals.
That I've understood.
Then on merit also, because they suppress the payment of tax, penalty was imposed under section 78.
Hmm.
That's legally imposed, Lordship.
When
And
you
once
come,
they have suppressed the, when they have now filed the ST3 return, let's say there are many judgments on this point, that when the SSC has suppressed the facts, they have not disclosed, then it is amounts to suppression of facts, suppression of material spec from the record.
when they have suppressed and when they have not filed the ST3.
Yes, sir, they have not filed ST3. It is
It's okay,
admitted.
they have not filed, but that is the reason they are imposing it.
No,
Any
Lordship.
judgment on that?
Yes, Lordship, there is a judgment. They have
But
not.
if,
filed.
if,
Lordship may kept
service
the
tax
judgment.
service tax is paid, but
Even then, Lordship,
without,
even then,
not filing the ST3 form,
Lordship, because it was, they
then
have to
it would
file.
amount to suppression.
Yes.
And the penalty can be imposed under
Yes, Lordship.
78.
Yes, that an extended period
Do
can
you
be.
have that?
Lordship, Lordship made the matters CAB. Tomorrow I'll submit a copy of the judgment. Copy to my learned friend also.
Okay.
Lordship, the act says if suppression of facts is there with an intention to evade payment of tax. There is no intention of payment of that is a wrong thing on their part. Section 78 is not invocable because it says it is leviable only if I have not paid the tax. Once I have paid the tax, Section 78 cannot be imposed. Secondly, suppression of facts, they are reading the line half. Suppression of facts with the intention to Lordship evade tax. Once the tax was already paid, even before their inquiry was included.
Any decision on that?
Yes, Your Lordship. Supreme Court judgment I have placed, Lordship, that Cosmic and Dry, it is as per their own circular. This is the judgment which they have relied on in their own circular, which master circular I had given to Your Lordship.
Yes.
Cosmic and Dye, Lordship, judgment.
Yes, heard MS in Haveli Land Council. And also heard Mr. S.C. Kaya, learned Standing Council G, CGST. Hearing concluded, judgment reserved.
Much obliged.
Let us see.
Not.
If you want to submit, you may submit.
Tomorrow I'll submit copy.
A copy may be given to us.
Definitely, I'll myself submitted that I'll supply copy to my learned friend.
Much
Not like them, that they have not supplied copy to us.
What? Lordship, personal. Always personal. Much obliged. Thank you.
Nice to meet you.